committee will come to order. When we recessed, the gentleman from Kentucky had yielded to the gentleman from Virginia, and they had both yielded back. Does any other member wish to be heard? If not, the question is now on the amendment in the nature of a substitute. Those in favor signify by saying aye. Aye. Those opposed signify by saying no. Well, close, in the opinion of the chair. The opinion of the chair, the ayes have it. The amendment is agreed to. Question is now on favorably reporting H.R. 559 as amended. Those in favor signify by saying aye. Aye. Those opposed signify by saying no. No. In the opinion of the chair, the ayes have it. The bill is ordered favorably reported as amended. Without objection, the motion to reconsider is laid on the table. Our next item for consideration is H.R. 6391, the MSPB Reauthorization Act of 2018. The clerk will designate the bill.
H.R. 6391, to reauthorize and modify the authority of the Merit Systems Protection Board and for other purposes.
I ask unanimous consent the bill be considered as read and open for amendment at any point. Without objection, so ordered. I now recognize the gentleman from Georgia and sponsor of the bill, Mr. Heiss, for 5 minutes for a statement on the bill.
Thank you, Mr. Chairman. I also ask unanimous consent to add 2 letters from the MSPB into the record.
Without objection.
The Merit Systems Protection Board, created in 1978 by the Civil Service Reform Act, plays an important role safeguarding merit systems principles in the federal civil service. One of the main functions of MSPB is to hear appeals from federal employees who believe agencies have taken wrongful action against them, such as removals or suspensions for performance or misconduct. It is comprised of 3 members chosen by the President with the advice and consent of the Senate. Currently, a lack of a quorum exists at MSPB, meaning the full board cannot hear appeals initially decided by agency administrative judges. The President has nominated 3 new members to the board, and we urge the Senate to swiftly consider their credentials so that the current backlog of 1,250 cases can be decided. But there are other problems that exist at the MSPB beyond the lack of a quorum. Authorization for MSPB expired in 2007, and as an agency squarely within this committee's jurisdiction, it is our duty to reauthorize it. As we consider reauthorization, it's important this committee look at changes to MSPB to improve the agency's ability to meet its mission. Current MSPB Vice Chairman Mark Robbins submitted proposals to us on April 26th of this year to make such changes, and my bill includes several of them as well as others. The bill I sponsored would reauthorize appropriations for MSPB during the next 5 fiscal years, ensuring the agency can continue to perform its important work. It would also require MSPB to institute a filing fee for cases not related to whistleblowing, to reduce frivolous appeals or appeals that are clearly outside the agency's jurisdiction. In fiscal year 2017, MSPB received 5,406 appeals in regional and field offices for review by MSPB administrative judges. Of those, 57.6% were dismissed without MSPB looking at the merits of the case. The proposed fee, which is limited to no more than 50% of that required for filing a civil action in federal district court, is refundable to the appellate employee if he or she is found successful at MSPB. The current filing fee in U.S. District Court is $350. We do not wish to prevent valid appeals of agency actions that violate merit system principles. However, we also want to ensure frivolous appeals do not bog down the MSPB's review process or worse, chill an agency from taking action against that employee if their performance or misconduct warrants it. My bill also provides MSPB with the ability to grant motions for summary judgment. Under current law, MSPB must sometimes hold a hearing when there are no material facts in dispute. The Government Accountability Office reported in 2016 that members of a focus group convened to discuss summary judgment at MSPB, and they believed summary judgment would create greater efficiencies. These members also believe summary judgment would help separate valid complaints from meritless complaints where there are no facts in dispute. GOA found it can take 6 months to a year to remove a federal employee, and that's before the appellate process begins. Once appealed, MSPB regulations provide board employees 120 days to adjudicate cases, although in recent years it's taken as long as 499 days to complete initial appeals. Summary judgment, which other independent agencies such as the Equal Employment Opportunity Commission and the Federal Labor Relations Authority already have, and it will help to ensure timely processing of appeals at MSPB, which both benefits the employee and the federal government. My bill makes other important changes at MSPB consistent with recent Department of Veterans Affairs Accountability and Whistleblower Protection Act. It would prohibit MSPB from mitigating agency disciplinary decisions unless they are wholly unjustified, and it will reduce the standard of evidence by which MSPB considers appeals. We've heard from agencies that the lower standard of evidence, which is already in law for performance-based actions, will especially make a difference in instilling a culture of accountability. The most recent Federal Employee Viewpoint Survey found only 31% of federal employees agreed with the statement that steps are taken to deal with poor performing employees who cannot or will not improve. The lower standard of evidence will incentivize agencies to take action when employees engage in misconduct or fail to meet expectations, actions that would not otherwise be taken due to the complex, time-consuming, and difficult process for removing federal employees. Consistent with changes made by the Merit Act, my bill also limits the ability of senior executives to appeal furloughs of 14 days or less to MSPB. It also prohibits appeals for emergency furloughs, which are furloughs due to a lapse in appropriations. Finally, my bill allows for the reappointment of members to the full board. In summary, my bill will make important process changes at MSPB that will help it to quickly and efficiently process cases while also protecting MSPB's role as an independent protector of merit system principles and whistleblowers. I urge my colleagues to support the bill, and I yield back.
Gentleman from Georgia yields back. The gentleman from Maryland is recognized.
Thank you very much, Mr. Chairman. I strongly agree that the Merit System Protection Board needs to be reauthorized. Unfortunately, that seems to be the only point we agree on. We should be looking for ways to strengthen MSPB's ability to safeguard merit system principles and provide an independent review of personnel actions. This legislation would do just the opposite. It would weaken the protections that were put in place to ensure an unbiased, nonpartisan civil service. The effect of this bill would be to make it easier to fire federal employees and move toward at-will employment. I fundamentally disagree with that objective. The bill would require MSPB to charge a fee for filing an appeal with the agency. The current fee for filing civil complaints in the United States District Court for the District of Columbia is $400. I know hardworking federal employees in lower general schedule grades who are living from paycheck to paycheck. They wouldn't be able to afford a $200 filing fee. Wouldn't even be able to afford a $100 filing fee. These dedicated men and women who work day in and day out to serve the American people would not be able to afford to file an appeal if MSPB charged a fee. This bill also would make it harder for employees to defend their rights on appeal. I've often said it's one thing to have a right, it's another thing to be able to exercise it. What if an employee was unjustly terminated from her job? What if this employee blew the whistle on an agency not complying with the law? and rather than addressing the problem, the agency retaliated against her. This committee has seen this happen time and time again. Let me remind everyone that this has happened at the VA, where whistleblowers who disclose the agency's manipulations of patient wait lists, over-medication of veterans, and improper treatment of veterans. They were harassed, they were sidelined, they were ostracized, blacklisted, and terminated. This bill would make it more difficult for whistleblowers like them to seek redress from retaliation. Even if an employee were able to pay the filing fee, this bill would make it much harder for the employee to challenge and overturn the agency's decision. The bill would lower the evidentiary standard that an agency must meet for the MSPBs to uphold the agency's action. For an employee, this means that he or she has a higher burden of proving that the agency's decision should be overturned. This bill also would prohibit MSPB from mitigating the penalty imposed on an employee, even if it found that the penalty was too harsh. The only exception to this rule would be if the agency's action was determined to be, quote, wholly without justification, end of quote. In practice, this would apply only to those rare situations in which employees actually won cases on appeal. This bill would create financial barriers to employees seeking to appeal, make it far easier for agencies to win any appeal, and hamstring MSPB's authority to address legitimate complaints. In closing, this is a terrible approach to managing the Federal Civil Service. It is inspired by conservative think tanks and backed by big money donors intent on crippling federal employee unions for decades. I have no doubt that this bill will pass our committees stacked as it is with supporters of that agenda. If enacted, it would degrade the nonpartisan, merit-based civil service that has served our nation well for over a century. With that, I urge the committee to reject it, and I yield back.
The gentleman from Maryland yields back. Does any other member wish to be heard? The gentleman from Virginia, Mr. Connolly.
I thank the Chair, and I wish to associate myself with the remarks of the distinguished ranking member. I thank Mr. Heiss for making the effort to provide the reauthorization that is needed for the Merit Systems Protection Board, but it's all the other ornaments attached to this tree that make this bill unacceptable for most of us on this side of the aisle. This bill raises the hurdles of a federal employee in terms of an appeal and in terms of merit protection. And I suppose it has to do with a philosophy or an ethos of presumption. Heretofore, the ethos of presumption has been that a federal employee has a legitimate grievance that needs to be heard and protected. If we adopt this bill this way, we are radically shifting that ethos of presumption to one in which we believe you're gaming the system. We're going to create hurdles for you to exercise your appellate rights because we think in advance, a priori, that there's no merit to your complaint or your grievance. I don't think that's a noble way to treat our federal workforce. I think that's a radical departure from past practice. If there were abuses in the system, and there are abuses in every system, they could have been addressed. But to wholesale change the presumption in the system, which is what is in front of us today, I think is wrong, and a disservice to the hard men and women, working men and women, who serve our publics and our constituents. I yield back.
The gentleman from Virginia yields back. Does any other member wish to be heard? The gentleman from Pennsylvania, Mr. Cartwright.
Thank you, Mr. Chairman. I join my colleagues in thanking Mr. Heiss for reauthorizing the MSPB, but also in objecting to the changes that are made to it. You know, we have federal employees. We're a federal government. We're going to have employees that help us run it. And there is one rule about employees that they can go off and work someplace else if you don't treat them right, if you don't pay them well, if you abuse them, if you take their rights away, they will wander off. And it seems like in this room, that's all we talk about is giving worse and worse treatment to our federal employees and lower and lower pay if we can get away with it. And it sends a very strong signal in this country. Don't come to work for us. We're not good employers. We don't appreciate you, and we don't want to pay you, and we want to take your rights away as workers. Well, you know, we're all good capitalists here, and under the capitalist system, people are free to go off and work in other places if you treat them like that. This is a bill that takes away, does nothing to workers' rights except take them away. It starts this idea of summary judgment. Most people in America would be surprised that there is such a thing as summary judgment. In a place like America where access to justice is assumed, did you know that you can have your right to your day in court taken away by something like summary judgment, where an unaccountable official, without a trial, without a hearing, can simply decide you don't have a case? Now, I understand that a focus group may have liked that idea, but I don't. And I think most Americans don't either. And I understand that this is an amendment that would add a fee to taking an appeal. And explicitly, the purpose of that fee is to cut down on appeals. It's not that they need the money. It's not that there's additional paperwork that has to be covered by this money. No, this is explicitly to discourage employees from exercising their appellate rights. This runs counter to everyone who believes in open courts and full and fair justice for everyone. You know, to regular, ordinary Americans hearing about this for the first time, they should realize this is nothing but beating up on federal employees. If we continue to do that, they are going to wander off. The best ones will have other opportunities in the workplace, and we're going to be left with whoever you get when all the good employees wander off and work at places that don't abuse them and take their rights away and complain about them and act like they're undesirable the way bills like this do. That's all I have to say, Mr. Chairman, and I yield back.
The gentleman from Pennsylvania yields back. Does any other member wish to be heard? The gentlelady from the District of Columbia.
Mr. Chairman, I can't imagine why this committee would use the reauthorization of the Merit Systems Protection Board as an excuse to once again go after federal employees. Isn't it enough that it's almost impossible to get a raise if you are a federal employee? Isn't it enough that working for the federal government with no increases now for years means you are showing some particular allegiance to your government? This is an undisguised attempt to rob federal employees of the due process that they have always had. I mean, it's really minimal to go through an administrative process. In fact, why did we set up an administrative process? Here as elsewhere, because the administrative process is low cost and because it deters going to federal court. So why would we want to discourage use of the administrative process by the unheard of notion of a fee on filing in that administrative process. And it doesn't even take into account that while there are some employees who earn more pay through seniority, almost all of them through seniority, many are low-wage employees. So what is the point? What are we afraid of? The Merit Systems Protection Board is regarded as fair. It knows how to deal in short shrift with appeals that don't have any merit. They haven't asked for our help. So who this will hurt are the lowest wage employees of the federal government, unless they can get some kind of help and from maybe their unions or perhaps some pro bono help. Why in the world? Then this notion of changing, again, the due process standard from preponderance of the evidence to substantial evidence, again, means that this committee feels that it has something to fear when employees want to lay their evidence out to show that they have been unfairly treated. What's the basis for this, I'd want to ask? Did either the Merit Systems Protection Board, did federal did federal agencies come to us and said, you really ought to change this because there has been abuse of the system? So maybe if you raise the level of proof necessary, there'd be less abuse. If so, that was not, those facts were not put before this committee. I don't know why we would want to subject federal employees to penalties that they have not earned, and I urge the rejection of the amendments to the Merit System.
Would my colleague yield for a quick question?
Glad to do so.
Does the gentlelady from Washington, D.C. recall, or is my memory faulty, that the recently departed administrator of the EPA, Mr. Pruitt, was publicly cited for retaliation against employees at the EPA for, in a sense, whistleblowing on him? Is that my recollection? Is that accurate?
That recollection is accurate, and if anything, it seems to me we'd be looking at agency heads and not employees. And the last thing this committee ought to want to do is to discourage whistleblowers. We've had very strong whistleblowing legislation. We ought to be encouraging that phenomenon, and I thank the gentleman for his question.
Gentlelady yields back. Does any other member wish to be heard? Gentleman from Georgia.
Thank you, Mr. Chairman, and I, first of all, just want to say thank you to my colleagues on the other side for their willingness to reauthorize this. But just a couple of quick comments. First of all, just by way of a reminder, Vice Chairman Mark Robbins has worked very closely with his committee and offered many of the proposals that are in this bill. That is, so we've been working together in that regard. And I would just say that the whistleblowers are waived from the fee altogether. That came up. They don't have a fee. Whistleblowers are not hurt whatsoever. They're clearly protected in this. And this really brings MSPB into consistency with other agencies that are already implementing the things that are proposed in this bill. And so it just puts a level playing field across the government. And I would just urge our colleagues to remember these things, and I urge support for it. Thank you. I yield back.
Gentleman yields back. Does any other member wish to be heard? If not, the question is on favorable to reporting H.R. 6391. Those in favor signify by saying aye. Aye. Those opposed signify by saying no.
No.
In the opinion of the chair, the ayes have it. Gentleman has requested a roll call vote. A recorded vote, as previously announced. Further proceedings on the question will be postponed. Gentleman for what purpose does the gentleman from Virginia seek recognition?
Mr. Chairman, I seek recognition in order to make a motion.
Subject to the right to object, the gentleman is recognized.
I thank the chair. Today I ask that our committee be allowed to debate and vote on 6 subpoena motions involving multiple agencies and issues summarized in a letter sent to you, Mr. Chairman, by the Ranking Member, Mr. Cummings, on July 13th. Mr. Cummings, in that letter, summarized each one of these requests. The subpoena motions today span a variety of topics, from the Trump administration's decision to take the position in Federal court that key provisions of the Affordable Care Act are unconstitutional, to the vetting process that enabled a contractor with an open warrant for murder to access the White House complex itself, to the administration's proposed gag rule for Title X health care providers. As with each prior motion, we've already written letters explaining our requests. We explain why the documents sought were critical to our investigations and oversight of the Federal government. The White House, 4 Federal agencies, and a private intelligence agency have refused to produce the requested documents. Mr. Chairman, so far you have failed to issue a subpoena unilaterally. So now we ask that the full committee be given the opportunity to vote on these subpoenas as allowed under our committee rules. If we cannot obtain the documents we need to conduct investigations, we're unable to conduct the vigorous oversight the American people elected us to provide and expect us to provide. Today marks the 5th time that we, on this side of the aisle, have asked during business meetings to let our committee vote on subpoenas covering issues of critical importance to the public. The past 4 motions were ruled out of order. No doubt this one will be too. No subpoenas were issued, and the committee did not have an opportunity to debate or vote on the motions. I would hope for a different result today. I hereby move that this committee authorize and issue subpoenas for documents and testimony on the 6 topics as described in Ranking Member Cummings' letter to the Chairman already referenced. That is the letter on Friday, July 13, 2018. The motion is at the clerk's desk.
Gentleman yield.
I certainly yield to the distinguished Ranking Member.
Mr. Chairman, I want to second the motion and associate myself with the words of the distinguished gentleman from Virginia. As you know, Democratic members have asked for you to issue, or at least let us vote on, more than 50 subpoenas since you have been chairman. You blocked each and every one of them. And it's not because the Trump administration has suddenly been cooperating with our request. To the contrary, they've been openly denying our requests with absolutely no repercussions. We should be conducting vigorous oversight of the President and his administration. It's our job. It's our constitutional duty. Without rigorous oversight, with that constitutional check, we've already seen how members of the Trump administration have become mired in scandal, wasted taxpayer dollars, and abused their authority with no accountability. Chairman, during your term, you refused to issue even one single solitary subpoena to anyone, not to a Trump official, to a private individual, or to anyone else. I ask that you reconsider your decision to block our oversight efforts and allow us to do our job, that is, to be a check on the executive branch of the United States of America.
Reclaiming my time, and I thank the distinguished members. Anyone else? I got a minute. Mr. Chairman, I would ask unanimous consent that the letter sent to you on July 13th by Ranking Member Cummings outlining the 6 areas we're discussing be entered into the record at this point.
Without objection.
I thank the Chair, and I yield back.
The gentleman yields back to my friend from Virginia and my friend from Maryland. The motion is improper because the item is not on the agenda. Our next item for consideration is H.R. 5300, the Federal Information Systems Safeguards Act. The clerk will designate the bill.
H.R. 5300 to provide agencies with discretion in securing information technology and information systems.
I ask unanimous consent the bill be considered as read and open for amendment at any point. Without objection, so ordered. I now recognize the gentleman from Alabama, the sponsor of the bill, Mr. Palmer, for 5 minutes for a statement on the bill.
Thank you, Mr. Chairman, for holding this markup today. H.R. 5300 is a bill that the committee has considered before. Last Congress, this committee favorably reported this bill to the House, and the House passed it with bipartisan support. The federal government's most important responsibility is the protection of this nation, and that includes our citizens against all threats and attacks, including our nation's information systems. As everyone on this committee knows, the breach of the federal information systems at the Office of Personnel Management, OPM, was one of the worst in our history. The OPM breach exposed the personally identifiable information of over 21 million federal employees, retirees, and family members. The breach also compromised highly sensitive background investigative information, including fingerprint data of federal employees with security clearances. I think everyone on the committee realizes the national security implications of the OPM breach will be long-lasting. Following the breach to tighten IT security against future cyber attacks, OPM informed their employees that they could no longer use the OPM network to access Facebook and personal email. In response, the American Federation of Government Employees Union argued OPM could not take away this benefit without first providing the union the opportunity to bargain. The union cited a 2014 ruling by the Federal Labor Relations Authority striking down an identical effort by the Immigration and Customs Enforcement to strengthen their cyber defenses by denying access to personal email and Facebook while using a federal network. As the members of this committee may recall, ICE's IT systems had been breached, and they traced it to employees using the ICE data systems to access their personal email and Facebook. In a 2-to-1 vote, the Federal Labor Relations Authority said the imprecise wording in the Federal Information Security Management Act, FISMA, on agency IT security responsibilities failed to demonstrate congressional intent to vest with the agency the sole discretion over protecting information systems and networks. In other words, 2 Federal Labor Relations Authority members took a position that left federal employees exposed to future breaches and the exposure of their personally identifiable information. The Federal Labor Relations Authority dissenting member wrote, and I quote, "I cannot conclude that Congress intended for our statute to be read so expansively as to impose additional, and in this case bargaining, requirements on federal agencies before they can act to secure the integrity of their federal IT systems, the breach of which could directly impact our nation's security and economic prosperity." H.R. 5300, the Federal Information Systems Safeguard Act, amends FISMA to make clear to the head of a federal agency that they have the authority to take appropriate and timely action to secure their IT networks. The bill will enhance the agency's ability to deploy timely cybersecurity measures, defend against cyber attacks, and protect critical information databases and federal employees' personally identifiable information. The need for federal agencies to have the ability to secure their networks in a timely manner should be obvious, especially considering the breaches already experienced and the constant assaults against our government information systems. According to the Federal Information Security Modernization Act report to Congress, federal agencies endured 35,277 cybersecurity incidents in fiscal year 2017, which is a 14% increase over 2016. It should also be obvious that denying agencies this authority puts America's information systems and federal employees at greater risk. Federal agencies have a responsibility to protect their IT systems, and they should be able to carry out that responsibility without unnecessary interference or hindrance. This legislation is an important step we can take now so federal agencies can take quick action to secure their IT networks and data from cyber attacks and protect the personally identifiable information of federal employees. Before yielding back, I would like to ask unanimous consent to enter into the record a Washington Times opinion piece that I co-authored with former Chairman Chavitz titled, "How Collective Bargaining Undermines Cybersecurity." With that, I urge the support for H.R. 5300, and I yield back.
Gentleman from Alabama yields back. The gentleman from Maryland is recognized.
Chairman, I strongly oppose the legislation. This bill refers to the authority of agency heads to take, quote, any action, end of quote, to limit, restrict, or prohibit access to a website or test, deploy, or update a cybersecurity measure if they determine the action is necessary to carry out their responsibilities under the Federal Information Security Management Act. Let me repeat that. Any action, any action. That language is dangerously overbroad. Could any action include overriding contracting requirements, Could it include the Federal Records Act or transparency laws such as the Freedom of Information Act? What about the Data Act or the Privacy Act? As I understand it, this legislation is intended to clarify that agency heads can block web-based email on agency computers without following requirements to bargain with the local union over the impact and implementation of such a change. There's no question that we need to protect our federal IT and information systems from cyber threats. I strongly support that goal, but no matter what you believe about blocking employee access to email, this bill will go well beyond that. This committee has not received a technical assistance on this bill from the Department of Homeland Security or the Office of Management and Budget, which seems always to be required for Democratic bills. When asked about a similar version of this bill introduced last Congress, DHS raised concerns that the bill could conflict with authorities over cybersecurity given to OMB and DHS. Finally, let's recognize the amendment for what it is, yet another attack on employee rights and collective bargaining. The American Federation of Government Employees opposes this bill. The National Treasury Employees Union also opposes this bill. They wrote, and I quote, "Under the current Title V statute, federal employee labor organizations cannot bargain over an agency's IT actions or decisions," end of quote. Instead, federal unions have a limited right under current law to negotiate arrangements for employees adversely affected by an agency's IT security actions. For example, a union might seek to provide employees with access to a computer not connected to the agency's IT systems so employees can access personal email when access has been blocked on work computers. And that's reasonable. Federal employees, like many other working Americans, need to be able to be contacted in case of emergencies, such as those involving a family member or a closing of their child's school. We can protect federal computer systems without the unnecessarily broad language included in this bill. And we can protect federal computer systems without eroding employee rights. And with that, I yield back.
Would the gentleman yield?
Yes, I will.
I thank my friend from Maryland. I just want to, I associate myself fully with his remarks, and this is of a piece. It's now our third bill. We've gone after dispute resolution for federal employees. We've gone after their appellate rights, and now we're going to go after collective bargaining. I would say to the distinguished ranking member, I serve as the ranking member, as he knows, of the Government Operations Subcommittee. We've had a series of joint hearings with the IT Subcommittee, bipartisan. I have not sat through a single hearing where a single shred of evidence was presented to us by anybody that collective bargaining was a threat to the compliance with FISMA. I have not heard a single shred of evidence that collective bargaining, frankly, in any way impedes our ability to try to do what we need to do by way of modernization and upgrade in the IT management within the federal family. And I think we're fixing a problem that isn't broken, and it is, unfortunately, another part of this longer narrative aimed at the federal worker. Hiring freezes, salary freezes, whacks at their compensation, whacks at the terms of their retirement programs, both in FERS and CSRS, requiring them to pay more in and get less out. This is an assault on the federal employee, and it's going to make it much more difficult to recruit and retain the workforce of the future, given the fact that about 40% of the current federal workforce is eligible for retirement over the next several years. I yield back to my good friend from Maryland and thank him for yielding.
Reclaiming my time, I yield back.
Gentleman yields back. Does any other member wish to be heard? The chair will recognize himself and yield to the gentleman from Alabama.
Thank you, Mr. Chairman. In response to these charges against the bill, I'd like to point out that this bill is narrowly tailored and only clarifies that the agency heads can use the existing, not new, authority to secure their information technology without first having to obtain pre-clearance from the unions. The bill does not exempt agency actions from the host of protections that currently exist. It simply clarifies that the agency decisions to secure their IT systems are not subject to collective bargaining. And giving an example of this in response to why this is necessary not to have to delay because of collective bargaining, the cybersecurity response time is critical. We cannot take the chance in failing to deploy a cybersecurity tool because we must first notify a union and negotiate. In fact, in the OGR majority staff report on OPM data breach investigation, we found out that OPM tried to deploy a tool to manage network access control for devices that was not fully deployed until almost a year later, in part due to the union notification process. And, you know, for this argument that this is an attack against federal employees, the attack against federal employees occurred when their personally identifiable information was accessed by foreign operatives. That's 21.5 million federal employees. And it's, you know, I find it somewhat hypocritical that the union would be opposed to this when they sued OPM for failing to protect their employee data, when, as I just pointed out, it was their interference that contributed to it. So with that, and one other point in regard to federal employees being able to be notified by a school or a caregiver about a change in schedule, whatever. They've got, most of them, if not all of them, have cell phones, and if they need to be notified, they can notify their immediate supervisor. So this doesn't impact anybody's ability to be notified of changes in someone's schedule. With that, Mr. Chairman, I yield back and urge my colleagues to vote yes.
Gentleman yields back. The gentleman from Pennsylvania is recognized. Mr. Cartwright.
Thank you, Mr. Chairman. Mr. Chairman, as you're aware, in a 5-4 decision released last month, the Supreme Court of the United States ruled against unions in the case of Janus versus AFSCME and overturned 4 decades of legal precedent to undermine the freedom of teachers, police officers, firefighters, snowplow drivers, and all public service workers to negotiate for decent pay and fair workplaces. That court's decision invalidated the laws of 22 states and the District of Columbia, which allowed unions and state employers to agree to require that employees pay a fair share fee to cover the costs of collective bargaining and enforcement. That decision came at a time when hardworking Americans are fighting every day just to pay their bills and support their families. Mr. Chairman, today's markup really is a continuation of this multi-pronged attack on our federal workforce. All 3 measures, including this one, threaten decades of successful federal labor management efforts and damage the ability of labor unions to represent bargaining employees to provide the best service to the American public. Like the Janus decision, these 3 bills collectively are an outright attack on unions, an attack on working people, and an attack on the causes we fight for every day. Turning to this bill in particular, this really arises out of an issue that came up in July of 2014. In that year, in July, the Federal Labor Relations Authority issued a decision in a case between the U.S. Immigration and Customs Enforcement and the American Federation of Government Employees. In this case, the local union filed a grievance alleging that the agency blocked access to web-based email services without first negotiating the implementation of the new policy with the union. The arbitrator found for the union, and the Federal Labor Relations Authority upheld that ruling on appeal. The finding which directed the agency to bargain over the impact and implementation of the change in policy. This bill we're discussing now would overturn the FLRA decision, as if all those people who worked hard on this issue already didn't know what they were talking about. It also assumes, doesn't it, that when we describe it as getting pre-clearance from the union, That's not what this is about. It's about working it out with the union. It's about sitting down and rolling up your sleeves and coming to a sensible conclusion. When you call it pre-clearance from the union, it's as if the union is some sort of star chamber that doesn't listen to reason and doesn't care about cybersecurity. And that I object to. These are hardworking American citizens that belong to the AFGE, and they care about cybersecurity, and they care about cyber attacks on our nation. And to suggest otherwise I take umbrage at that, and I'm sorry to hear it, because everybody's interested in cybersecurity, and all the existing law does is make sure that the union is at the table when these decisions are made. If you look at the language of this bill, it just basically says, if the head of the agency determines such action is necessary. This means an unelected, unaccountable federal employee gets to decide all questions of cybersecurity without checking into the union, and we're talking about basically the cyber rights of employees that work for the federal government. For those reasons, I urge a no vote on this, and I yield back.
Would my friend yield for a quick question?
I yield to Mr. Connolly for a question.
I just wondering if my friend, the gentleman from Pennsylvania, is aware of a single example where somehow collective bargaining has jeopardized, interfered with, or been cited by any source with respect to cybersecurity or the protection of our cyber assets?
I was reclaiming my time. Thank you for the question, my friend, the gentleman from the Commonwealth of Virginia. No, I can't think of one, and I understand it has been submitted to the record without objection, a Washington Times article, an op-ed, which will make all of this clear to us, and I will read that with interest, and I'd like to hear this afternoon, if we might, an example of when cybersecurity was compromised, in fact, because of union intransigence. Yield back, Mr.
Would the gentleman yield? Would the gentleman yield?
I yield to Ms. Norton of the District of Columbia.
I'm really concerned, as the gentleman has implied, about the absence of evidence on virtually all these bills. You know, if we had had some hearings, I could understand it, maybe it wouldn't prevail, but it looks like the majority just plops down an anti-worker bill, and that's the long and short of it. I'd like to suggest what members may not understand. If a union files a grievance, that isn't anything. That grievance doesn't mean that the union has prevailed. What it does assure is that you hear another view. You take it into account. The union might well not prevail. And I'm not sure, since we're talking about Social Security, that the union would prevail. I'm not, again, sure of what the majority is afraid of in hearing the union's view, putting this in the repository of a single employee working for management with no ability to understand whether there is another side. You may want to take it into account or not, but when a union files a grievance, it does not assure that the union will prevail. So since it does not, and since we're talking about cybersecurity, I have yet to understand what the majority is afraid of that made them put forward this bill. I yield back.
And I yield back myself, Mr. Chairman.
Gentleman yields back. Does any other member wish to be recognized?
Mr. Chairman.
Gentleman from Maryland, Professor Raskin.
Thank you very much, Mr. Chairman. I'm also operating at a information deficit here. I'm not sure, did we have a hearing on this bill? No, we did not have a hearing. Okay, so forgive me, I'm going to ask a factual question. I just hope somebody can answer. I understand that there are certain law enforcement personnel who are not permitted to carry personal cell phones, and they are represented in collective bargaining and have an interest in the rules governing when and where they can use personal cell phones and being forced to use their business cell phones for personal calls home to family and so on. And I'm reading this to say that they basically would be excluded from any participation and discussion of that. And I want to know, one, is that right? And two, why would we do that? Wouldn't we want them to have the opportunity to participate in discussion of an IT policy relating to personal or business use of cell phones? Is there anybody who could answer that? I'm happy to yield.
This would not cover phone calls. This is personal email and addressing and accessing the personal Facebook page or shopping online.
Okay. So can you just explain what is the rationale, or what were the events that led up to this? And again, I don't mean to put you on the spot. We just haven't had a hearing, so I don't really know what's behind it. I'm not necessarily opposed to it, but I just don't see any reason for it, and I just want to know what the logic of the legislation is.
The logic is it's based on two breaches. One of the Immigration and Customs Enforcement Agency, and those breaches came through their employees accessing their personal email, Facebook, and basically shopping online. The second occurred at OPM when 21.5 million federal employees, both retirees, personally identifiable information was hacked into, which, as you know, puts them at risk of their credit being ruined, of their savings and other issues being at risk. And the point that I'm making is once an agency detects a cyber attack, there's not time. They need to be able to take whatever action is appropriate. And that would include suspending an employee's use of the federal systems to access email or Facebook or shop online. This is not punitive in any way. I'm frankly amazed at some of the comments that I've heard, because if I were a federal employee, I would hope that if a cyber attack were detected, that the agency would take immediate action to protect my personally identifiable information. And I can tell you, Mr. Raskin, I appreciate you giving me the opportunity to respond to this. Among those whose personally identifiable information was accessed at OPM were people who had security clearances.
Well, and just to
Not only did they get their personally identifiable information, they got their fingerprints.
Well, reclaiming my time, because I think we have a convergence of concern here. I represent 80,000 federal employees. Many of them, perhaps most of them, were victims of this cyber intrusion and cyber attack. And we're not talking about negotiating during a crisis. We're talking about just including them in the discussion of what the rules are going to be, including a rule governing the disposition of the data during a crisis. And I'm sure nobody, either on the management side or on the workforce side, would try to hold up rapid action in order to protect everybody's data. The question is, who gets to be in the room when we're deciding what's to be done? And I know that my constituents have a deeply vested interest in making sure that their data is protected, and I just don't know why we would exclude them and their representatives from participation in discussion and formulation of the policies that are going to protect everybody's data. So, but I appreciate your insight, and I yield back, Mr. Chairman.
The gentleman from Maryland yields back. Does any other member wish to be heard? If not, the question is on favorable to reporting H.R. 5300. Those in favor signify by saying aye. Aye. Those opposed signify by saying no.
No.
In the opinion of the chair, the ayes have it. The bill is ordered favorably reported. Without objection, the motion to reconsider is laid upon the table. Pursuant to notice, the committee will now consider the following postal naming bills en bloc: H.R. 4913, H.R. 5395, H.R. 5868, H.R. 5935, H.R. 6020, H.R. 6059, H.R. 6116, and H.R. 6167. I ask unanimous consent the bills be ordered favorably reported to the House of Representatives. Without objection, so ordered. Committee will now resume consideration of H.R. 599, the Merit Act of 2017. The question is on favorably reporting H.R. 599 as amended. The clerk will call the roll.
Mr. Gowdy?
Yes.
Mr. Gowdy votes yes. Mr. Duncan? Mr. Duncan votes aye. Mr. Issa? Mr. Jordan? Mr. Sanford? Mr. Sanford votes aye. Mr. Amash? Mr. Amash votes yes. Mr. Gosar? Mr. Gosar votes yes. Mr. Desjardins? Ms. Fox? Ms. Fox votes aye. Mr. Massey? Mr. Meadows? Mr. Meadows votes aye. Mr. DeSantis? Mr. Ross? Mr. Ross votes aye. Mr. Walker? Mr. Walker votes aye. Mr. Blum? Mr. Heiss? Mr. Heiss votes aye. Mr. Russell? Mr. Russell votes aye. Mr. Grothman? Mr. Grothman votes aye. Mr. Hurd? Mr. Palmer? Mr. Palmer votes aye. Mr. Comer? Mr. Comer votes yes. Mr. Mitchell? Mr. Mitchell votes aye. Mr. Gianforte? Mr. Gianforte votes yes. Mr. Cummings?
No.
Mr. Cummings votes no. Ms. Maloney? Ms. Norton? Ms. Norton votes no. Mr. Clay? Mr. Clay votes no. Mr. Lynch? Mr. Cooper? Mr. Connolly?
Nay.
Mr. Connolly votes nay. Ms. Kelly? Ms. Lawrence? Ms. Watson-Coleman? Mr. Krishnamurthy? Mr. Raskin? Mr. Raskin votes no. Mr. Gomez? Mr. Gomez votes no. Mr. Welch? Mr. Welch votes no. Mr. Cartwright? Mr. Cartwright votes no. Mr. Desaulniers? Mr. Desaulniers votes no. Ms. Plaskett? Ms. Plaskett votes no. Mr. Sarbanes?
How am I recorded?
Mr. Desjardins is not recorded.
Yes.
Mr. Desjardins votes yes.
How was Mr. Hurd recorded?
Mr. Hurd is not recorded. Mr. Hurd votes yes.
Gentleman from Illinois, Mr. Krishnamurthy.
Mr. Krishnamurthy is not recorded. Mr. Krishnamurthy votes no.
Gentleman from California.
Mr. Issa votes yes.
The clerk will report the tally.
On this vote, there are 19 ayes and 11 noes.
The ayes have it. H.R. 599 is ordered favorably reported as amended. Without objection, the motion to reconsider is laid on the table. The committee will now resume consideration of H.R. 6391, the MSPE Reauthorization Act 2018. The question is on favorably reporting H.R. 6391. The clerk will call the roll.
Mr. Gowdy?
Yes.
Mr. Gowdy votes yes. Mr. Duncan? Mr. Duncan votes yes. Mr. Issa? Mr. Issa votes yes. Mr. Jordan? Mr. Sanford? Mr. Sanford votes yes. Mr. Amash? Mr. Amash votes yes. Mr. Gosar? Mr. Gosar votes yes. Mr. Desjardins? Mr. Desjardins votes yes. Ms. Fox? Ms. Fox votes yes. Mr. Massey? Mr. Meadows? Mr. Meadows votes yes. Mr. DeSantis? Mr. Ross? Mr. Ross votes yes. Mr. Walker? Mr. Walker votes yes. Mr. Blum? Mr. Heiss? Mr. Heiss votes yes. Mr. Russell? Mr. Russell votes aye. Mr. Grothman? Mr. Grothman votes aye. Mr. Hurd? Mr. Hurd votes aye. Mr. Palmer? Mr. Palmer votes aye. Mr. Comer? Mr. Comer votes yes. Mr. Mitchell? Mr. Mitchell votes yes. Mr. Gianforte? Mr. Gianforte votes yes. Mr. Cummings?
No.
Mr. Cummings votes no. Ms. Maloney? Ms. Norton? Ms. Norton votes no. Mr. Clay? Mr. Clay votes no. Mr. Lynch? Mr. Cooper? Mr. Connolly?
Nay.
Mr. Connolly votes nay. Ms. Kelly? Ms. Lawrence? Ms. Watson-Coleman? Ms. Watson-Coleman votes no. Mr. Krishnamurthy? Mr. Krishnamurthy votes no. Mr. Raskin? Mr. Raskin votes no. Mr. Gomez? Mr. Gomez votes no. Mr. Welch? Mr. Welch votes no. Mr. Cartwright? Mr. Cartwright votes no. Mr. Desaulniers? Mr. Desaulniers votes no. Ms. Plaskett? Ms. Plaskett votes no. Mr. Sarbanes?
Gentleman from Ohio.
Mr. Jordan votes yes.
Clerk will report the tally.
On this vote, there are 20 ayes and 12 noes.
The ayes have it. The bill is ordered favorably reported.
Mr. Chairman.
Without,
You got him, sir.
without objection, the motion to reconsider is laid upon the table.
Mr. Chairman, ask unanimous, I ask for, that we have the requisite number of days to file minority views on the bills, just ordered.
Yes, sir.
Thank you.
I want to thank all the members for their time and their patience and their attention to the markup, and especially for the collegiality with which people debate issues, even upon those that they disagree with one another. I also ask unanimous consent staff be allowed to make necessary technical and conforming changes to the bills ordered and reported today, subject to the approval of the minority. Without objection, so ordered. There is no further.
Mr. Chairman,
The gentlelady from North Carolina.
I have a point of personal privilege. May I be recognized for one moment?
Sure.
I have a program that my office does called Teacher in Congress, and I bring one or two teachers to in the summer here to observe how Congress does its work, and they spend about 10 days in Washington. I have two teachers with me from the Forsyth County Schools who have been observing this week. They'll be here the entire week, and I wanted to recognize them, Christopher and Dustin, and they're in the audience. I would encourage all members to consider doing such a program, and if our office can be of help to you, it is a challenge bureaucratically, I will tell you, but we've gotten rave reviews from the teachers who do it, and we hope it will give them insights and help them better educate their students about what the Congress actually does, as opposed to what they might read about what we do. So I would encourage you, and I thank you for allowing me to introduce them.
Well, the gentlelady from North Carolina is certainly welcome. Among the many things that members on both sides of the aisle in this body agree on, it is that a teacher at some point along the way made an impact on our lives in a positive way. And I want to thank the gentlelady from North Carolina for her career in education and her devotion to the subject matter. And I want to thank the two teachers. I didn't know you were here. I'm glad we were on our best behavior today, even not knowing that. But to the extent you can go back and let folks know we get along a lot better than sometimes it's represented that we get along, do that for us. Not to minimize the differences, but the collegiality doesn't always make the news. So thank you, and thank you for what you do. There's no further business. Without objection, the committee stands. The gentleman from Massachusetts is recognized.
Mr. Chairman, a number of us have arrived after the vote, and we want to request unanimous consent that we might be able to record it on the previous roll calls.
Without objection, it will be shown as having recorded a vote as if you had been here.
Okay.
The gentleman from Massachusetts?
No on the first and no on the second.
Ms. Lawrence, gentlelady from Michigan.
I would like to be recorded as no. Thank you.
Gentlelady from New York.
Was that another meeting and on the floor? No, recorded as no. Thank you very much.
Ms. Watson Coleman?
Yeah, Mr. Chairman, I'd like to be recorded as a no on the first vote. Thank you.
Yes, yes. Gentleman from Ohio.
To continue the bipartisanship here and vote on votes that are already done, I'll go a yes on the first one as well, Mr. Chairman.
Mr. Jordan was a yes, yes. With that, if there's no further business, without objection,
Mr.
the
Chairman,
committee's...
thank you for your courtesy, and I thank my colleagues as well. Thank you.
Yes, sir. We are adjourned.
That's the craziest thing is actually, that's what I